folks, we have a very special treat today. We have David Thompson, a constitutional attorney and the managing partner of one of the most important prestigious law firms in the United States, Cooper & Kirk. David Thompson, as I found out in November at a panel for the Federalist Society with Judge Thapar of the U.S. Court of Appeals for the Sixth Circuit, David's firm is literally handling over 50 Second Amendment related cases in the courts in America today. He is a member of the United States Supreme Court Bar. Their firm is literally the lead counsel in the Vanderstock case dealing with Joe Biden's so-called ghost gun rules. And I wanted to talk today with David about where are we in the world of Second Amendment litigation. And there's no better person to talk to than David Thompson, who is literally in the battlefield, on the battlefield every day, fighting on the front lines against these crazy gun control laws all across America, mostly in those blue states, you know, the usual suspects. So David Thompson of Cooper & Kirk, thank you so much for joining us here at the Four Boxes Diner today.
Thank you, Mark, for having me back. It's great to be back on the Four Boxes Diner.
Excellent. I think we did this a year or two ago. It's been a long time, so I'm glad we finally got you back on the show.
Thank you. It's been too long indeed. Absolutely.
So I just want to start. I'm sure everyone is out there is going to ask you this first question, which is, so David, where are we in Second Amendment litigation today? Should we be happy, sad, depressed, optimistic? Where exactly are we in the fight for our right to keep and bear arms and our Second Amendment rights?
Well, Mark, it's an exciting time to be a Second Amendment scholar or lawyer. And I was a history major in college. And I think to try to put this in historical perspective, the closest thing I can point to from history is Brown versus Board of Education. That's the decision from 1955 when the United States Supreme Court said that there could not be segregation in the South. And then there was years of massive resistance from the lower courts and finally capitulation. And we're seeing that here in the Second Amendment context too. Heller in 2008 was a thunderbolt announcing what has always been true, that there was an individual right to keep and bear arms. But for the next 14 years, we saw a lot of resistance, really massive resistance from many, many of the lower federal court judges who pretended that Heller did not mean what it plainly said it meant. And then in Bruen, the United States Supreme Court reaffirmed we meant what we said. This is an originalist test. And in Rahimi, they have reconfirmed this as well. So now everybody understands what the rules of the road are, what the test is, and we are beginning to see many lower federal courts to faithfully apply these tests. We're nowhere near done, but we are marking up and racking up some significant victories, which is really nice to see.
Well, David, we cover here on the Four Boxes Diner kind of America's litigation involving the Second Amendment. And it's pretty clear to me that if you look at the number of wins for the right to keep and bear arms that we've experienced between June of 2022, when the Supreme Court issued the Bruen decision, and today in the year of our Lord 2025, it's amazing the number of huge Second Amendment related wins we've experienced. And if you compare that with those relatively few, if any, Second Amendment wins between 2008 and 2022, it's a big difference. Can you speak to that a little bit?
100%. The test we had that was emerged and created improperly by the lower courts after the Heller decision was so-called intermediate scrutiny. Here you had activist judges saying, look, we know the text says the right of the people to keep and bear arms shall not be infringed, but instead we're going to say if there's an important reason, and there's public safety, so there's always an important reason, and if it's reasonably related to the legislative aims, and we're going to defer to the legislature, then the law's okay. And under that lazy logic, which is totally inconsistent with the text and history of the Second Amendment, basically every anti-gun measure in America, more or less, was being upheld. And now the courts have said, no, we're not going to do that. We're not empowering judges to put their judgment and the legislature's judgment over and above what the founders created this clear textual right. It is limited by the historical understanding in 1791, but that is the only limit. And the founders gave us this right. It was codified and it needs to be honored. And so now as courts are beginning to faithfully apply to that, we're winning because, spoiler alert, at the time of the founding in 1791, there weren't a lot of crazy anti-gun laws. And so if you actually faithfully apply this test, we're going to win a lot.
That gets to an issue, a general issue, David, of the notion of originalism. When you read some of these decisions and op-eds and scholarly pieces by people that clearly don't like the founding fathers, they don't like the Constitution as it's written, they certainly don't like the Second Amendment, and it's not clear to me they like some aspects of the Constitution, like the Electoral College. But when that's said, one thing that comes up quite a bit is the notion of originalism. Could you just, as a Supreme Court litigator, explain to the audience what exactly is originalism and why is that a good thing to be doing versus letting judge make it up as they go along? How does all this work at a high level?
Originalism tries to honor the intention of the founders as expressed first and foremost in the text of the Constitution itself. And then secondly, with any historical context from the time of the founding or the relevant amendment that explains what the text was understood to mean at the time that was promulgated. And that for 200 years is what judges did in the United States. It wasn't called originalism. It was called being a judge. And then in the 1960s, the liberals started inventing all sorts of crazy rights, and they moved away from trying to interpret the understanding of the founders. And it wasn't until Justice Scalia and Judge Bork and Attorney General Meese came along in the mid-'80s and said, this is crazy. We need to get back to what we originally did, to the original meaning and intent of the document. And, if liberals can convince legislators to do things and it's constitutional, fine. But there are no shortcuts by imposing on Americans and taking away our rights by running to the courts, which is what they were doing again and again and again. And so that's the distinction between, activists and originalists.
It's funny, David, how, you read these articles and comments by really anti-gunners, and they like to laser focus on the history of gun regulation. But somehow they miraculously skip over the most important history of them all, the text of the Constitution, which is not just the ultimate historical document for American law. It is the superior. It is the leading law of the land. It is the law that is above all else. And it's crazy how when they talk about we can't do history, we don't understand history. History is so hard. They want to pretend that the text of the Constitution doesn't exist and is not binding law. How does that work in the real world, David, in terms of the text of the Constitution being paramount?
You're right 100%, Mark. It is paramount, and that's why the burden shifts to the government. And that's important. The burden of proof is important because if there is no evidence, let's say any historical evidence that would support a gun control law, then that silence dispositively supports the the pro Second Amendment community and the text of the Second Amendment, and the text of the Second Amendment stands. So it's a really important thing. And I might just add that these, activists who claim, well, we can't do history. That's what lawyers and judges do. What do you think they're doing when they read Marbury versus Madison from the time of the founding or the Federalist Papers? They're doing history. So this is precisely what judges and lawyers learn from the first day of law school.
Yeah, it is kind of amusing that people that are literally elected, for example, to the United States Senate under the U.S. Constitution and serve for 6 years say, how can we possibly understand what the Constitution means when they're literally sitting in a body in Washington, D.C. as a senator created by the constitutional text. And somehow when it moves over to the Bill of Rights and the Second Amendment, somehow the text has no meaning, but it has a lot of meaning when it comes to giving them 6 years in the U.S. Senate, for example.
100%. And this is all just feigned ignorance. They know exactly what the Second Amendment means and the First Amendment and the other amendments and, of course, the text of the Constitution itself. And so this is just, another manifestation of massive resistance. Anyone who says, I can't do history, I'm just a judge, I'm just a caveman, forget it. They are being intellectually dishonest because that's what judges and lawyers do every day.
100% correct. And again, there is no such thing as historical silence when it comes to our fundamental right to keep and bear arms, because the ultimate history is the text of the Second Amendment in the U.S. Constitution itself, which again is a historical evidence. It is historical documents. Now, with that said, David, let's turn to a tour, if you will, of the battlefield, a tour of the Second Amendment battlefield. There's a lot of battles out there. I know your firm is involved with dozens and dozens of cases, which I'm sure the public was interested to hear back in November when you spoke on the Federalist Society panel at the National Lawyers Convention introduced by Judge Thapar of the Sixth Circuit. So can you just sort of walk us through generally first, and then we'll break it down into specifics. Where are we in the general Second Amendment battlefield in terms of what kinds of cases, the categories of cases, where are we in the courts, kind of what's the big picture to start with of the battlefield fighting for our Second Amendment rights in America's courts today?
Well, so there's some big ticket items that haven't been resolved. There are issues relating to where you can carry a firearm, who can carry a firearm, and what type of firearm can be carried. And so maybe we can talk about them. And then there's some miscellaneous issues that we can talk about. But those are the three big ticket issues. And let's start with where, where you have a right to carry your firearm. And the good news is we have had some success on this. One of the things that the left-wing anti-gun jurisdictions have tried to do is create a default rule that would essentially render the Second Amendment a nullity. They say, unless you have permission from someone, affirmative permission, posted a sign in a store to bring in a firearm, then the default rule is you're not allowed to bring in a firearm. And obviously most stores don't want to get involved into contestation over Second Amendment, so they're not going to have a sign either way. And what this would mean is you could carry a firearm, basically anywhere other than a public sidewalk. And fortunately, the Second Circuit Court of Appeals has struck that down. A trial court in New Jersey has struck that down, and the Third Circuit Court of Appeals allowed that injunction to stay in place. Unbelievably, the Ninth Circuit has said that California's law is invalid, but Hawaii's is okay. California's was invalid because you had to post a sign, whereas in Hawaii, consent could be given through a sign or verbally. So that's, a terrible decision and creates a circuit split, which think means it's likely that at some point that case will go to the United States Supreme Court. That's one of the big fights where we've had some success. Another place where we've had success is with places of worship. The anti-gunners have said you can't bring a gun to church. And just as a matter of public policy, that's absurdly stupid. You wouldn't want to take people who are vulnerable and a target and then make them even more vulnerable by saying you can't have a firearm to protect yourselves. Fortunately, at the time of the founding, there were a number of statutes that said precisely the opposite. You were required to bring a firearm to church at the time of the founding. And so the court in the Western District of New York had no trouble in joining that. And even the New York legislature said, okay, we're going to repeal that. We're also fighting over parks. And although some of the judges have acknowledged that, large national or state parks might not be a sensitive place, they have claimed that urban parks, well, that's different. It's an urban area. And, the problem with that is that the Boston Common was established in 1634. And from 1634, for the next couple of hundred years, there were firearms that were used on a regular basis for militia practice, but other purposes. And there was no prohibition on bringing a firearm into the Boston Common. And so that's a very ahistoric analysis as well. What we're seeing is a fight over so-called sensitive places. You could think of it as a gun-free zone, but the Supreme Court has called it a sensitive place. And in Heller and then Bruen, the court has identified 4 different so-called sensitive places. The first are schools. And we know from Rahimi that we need to extract a principle based on the how and the why behind the law to assess, okay, what is the significance of that history? Because it is true, from 1655, Harvard started limiting gun rights on school property. The key thing to note is it was only for students. So that's the how. It was only for students. There is nothing from the founding period suggesting that teachers or parents can't bring a firearm onto campus. And the other question is the why. And it's because those schools were deemed to be in loco parentis. They were deemed to have the rights of parents. So if we were to say, well, how does that translate into modern day America? The principle, based on the how and the why, would be if you're limiting students from bringing firearms onto campus and the school is assuming the responsibility of a parent for that child, then fine. So, if you're in high school, you probably can't bring a gun, and you're a student, you can't bring a gun. But the teachers can, the parents can, and that's an important distinction. So to the other places that the Supreme Court identified were courthouses, legislatures, and polling places. And so if we try to find Well, what's the principle to extract from there? We know from courthouses they had armed bailiffs. We know from legislatures they all had sergeant at arms and they had doorkeepers. And we know from polling places they were guarded by armed security too. So the common theme from those three, the three principles to be extracted from the how and the why, are comprehensive security. And that's why if you try to get on an airplane today, you're not going to be able to take a gun. There's comprehensive security. Likewise, at the United States Supreme Court, when you go and you argue there, you go and you watch a case there, you can't bring your gun into the courtroom. There's very comprehensive security. I think an interesting example is the White House. The White House at the time of the founding was not a sensitive place. Okay, you members of the public could go in and there was no prohibition on bringing a gun. Over time, that changed, and the security, armed security, metal detectors, it is a sensitive place now. You can't go visit President Trump with a gun in your pocket. It will be, taken from you by the metal detectors and the guards and the Marines. And so the government can designate places, sensitive places, provided they provide comprehensive security. And of course, it has to be a limited physical space that you're only visiting. They can't declare all of New York, comprehensively secured. Of course, that would be ridiculous. But even if they actually tried that, that wouldn't work, because it's confined to places where you're going to visit. So that's a big fight over where you can have guns.
Well, it seems to me that, tell me what you think of this, David. When I think about the notion of sensitive places, in many respects, we're really talking about secured places. I mean, the arguments that I've seen advanced dealing with other theories, because you remember, as you point out, the way this works as lawyers is you look at examples and you derive principles from this. I mean, if you want to apply it in the context of philosophy just for a moment, just think of the notion that says all men are mortal, right? A famous statement, very famous factual proposition. But how do we know that all men are mortal? The answer is we look at a series of examples of every man that's ever lived. And so far as we can tell, every man that's ever lived has eventually passed away and died. And therefore, from looking at those examples, we conclude that all men are mortal. Likewise, when you're dealing with Second Amendment litigation, the Supreme Court has said you're supposed to look at historical analog laws. Those are the examples. You get these examples that you agree upon, set aside the disputes as to whether or not they're appropriate analogs, but let's get into the fact they are analogs for the sake of the argument. And then what you do is you derive the principle from those analogs. And it seems to me, if you look at the examples that you've set out, that the Supreme Court has set out, is what might be a sensitive place, which is really a government-mandated gun-free zone. It does seem like the common theme is there was some level of security there. And it makes a lot of sense because the other theories, David, and I want to get your reaction to these other theories, notions to say, well, if other constitutional rights are being effectuated or exercised, we can deny you the ability to have guns there. If it's a core government function, whatever that means, I guess USAID is a core government function according to the left. I did not even know it existed, but now it's a core government function, I guess, according to the left. So how do you contend with these other theories, David, that says, well, really, if it's a core government function being exercised, we can take away guns. If it's also your constitutional rights are being exercised in some other way, we can take away your guns. How do you deal with those kinds of counter arguments?
The constitutional rights theory can't possibly be right because wherever you speak, you're exercising your First Amendment rights. Indeed, you have a right to life. So wherever you're breathing, you're exercising a constitutional right. So that proves far too much and can't possibly be right. And there's no historical support for it. As for this core government function test, the White House was performing a core government function. And it was not a sensitive place at the time of the founding. People were able to walk in, see President Jefferson and bring their firearms in. And so it just doesn't really match up with the analogs. As you say, you have to look at the analogs themselves and identify the how and the why. And, the why makes sense when there's comprehensive security because it means that your need to defend yourself for that finite period of time when you're visiting is reduced. So there's a connection to the purpose of the Second Amendment, which makes sense.
Yeah, I would take it goes even beyond that, David. I've made the case on this channel that, the basic rule in American life under American law is that the government has no duty to protect you. There's no legal duty to protect you against criminal conduct. There is an exception to that, however, and that is if you are technically in the custody of the police. If you're in the back of a patrol car, if they've locked you up in prison, then they have to take on the responsibility under the law to protect you and your life. And if they fail to do so, they can be held liable. They can be sued, for example. But that is not the normal course. So it seems to me commonsensically that, again, I have the right to defend myself everywhere I go in America. And the only exception to that should be if you say, Mark, you don't need to bring your gun into this particular building today, because we got your back. We're going to protect you from bad people that might try to bring guns in or try to hurt you and others. We're going to protect you with comprehensive security, including guns. We're going to provide the guns for you so you don't need to bring the guns with you, because we're going to take care of it and take on that liability if something goes awry. And that just makes sense to me. And again, it's an objective test as I see it. Either they're going to protect it. See, here's the thing, David, in my view, that you can't just label something sensitive and important and then not treat it that way, right? If I say, I think that's so important, but that I treat it poorly, my actions speak louder than words. So again, it seems to me, David, this theory of comprehensive security goes to, is the government really serious and truly believe that this is a sensitive place that's worthy of protection? Because labeling it such doesn't mean anything. What do you think about that?
I agree 100%. And Mark, I've seen some of your videos where you've saying you're your own first responder. And I agree with that 100%. But when the government says, yeah, that's generally true, Mark. But in this instance, when you're standing in the United States Supreme Court at the podium, we've got your back. We are your own first responder. We've got a whole phalanx of armed guards. We have comprehensive security. We've got metal detectors at every point of egress into the building. Then, okay, you can stand at the podium and you don't have to be, have eyes in the back of your head to worry who's going to attack you. And so it's that sort of thing that when they want to take on that responsibility and devote the resources, and it takes resources to do that, then they can designate a place as a comprehensive security, as long as you're visiting it for a finite period of time.
Right. Makes a lot of sense. Well, Dave, we can talk for hours about sensitive places, which are really secured places and or government mandated gun-free zones. But let's move on to the who. You said that another category is who can carry guns, who can possess guns. What's going on in the battlefield involving who can carry, who can possess, who can exercise their right to keep and bear arms, and some of the attempts under, for example, federal law 18 U.S.C. 922G to prohibit certain people from being able to possess firearms. Where are we now?
So there's two areas of contestation, Mark. The first relates to 18, 19, and 20-year-olds and turns on age. And then the second relates to people who have a record of some sort or otherwise have had involvement with the criminal justice system. So let's deal with the 18, 19, and 20-year-olds. This should be an easy case because at the time of the founding, in 1792, just 1 year after the adoption and ratification of the Second Amendment, Congress addressed the question. They had a Militia Act of 1792, and there was an active debate between President George Washington and his Secretary of War, Henry Knox, where they were debating, well, should we have the line be at 16 or 18? And at the end of that debate, Washington said it should be 18. He won the argument, and Congress codified that people who are 18, 19, and 20 had a legal obligation to provide themselves with their own firearms and to show up to muster for the militia, which is it's only one, but one of the purposes of the Second Amendment. And so the notion that at the time of the founding, they required these people to obtain firearms, but now they can't be allowed to, that's totally ahistoric. And I would also say, even if there were some sort of principle that justified it at the time of the founding, saying, well, for certain purposes, they were minors, they're not minors now. So the principle would be, minors can be stripped of certain Second Amendment rights. Well, 18, 19, and 20-year-olds are not minors. So we sort of have two reasons why we should win that pretty clearly. And the good news is we have been winning that. We just won this past week. My colleague John Ohlendorf argued and won in the Fifth Circuit Court of Appeals a case called Reese, which was attacking an extremely stupid and pernicious law that said if you're 18 years old, you can go at midnight into a dark alleyway and buy a used gun without a background check, out of the back of a van. But if you want to go into, Walmart and buy a new firearm with a background check, you are not permitted to do that. It just doesn't make any sense. It was insane all along. Unfortunately, the Fifth Circuit in the prior, intermediate scrutiny by an 8-7 vote upheld that. Judge Edith Jones just wrote a magnificent opinion that vindicated her prior dissent from 13 years ago, saying, no, under Bruen, under Rahimi and Heller, the history is clear, and 18, 19, and 20-year-olds can buy handguns from a federally licensed dealer. We've also seen the Third Circuit and the Eighth Circuit, in cases called Laura and Worth, respectively, say that, yes, 18, 19, and 20-year-olds have a right to carry a firearm. So that's really coming along. That Minnesota has filed a cert petition in the United States Supreme Court asking them to take that case. We'll see what they do, but we've been winning that issue everywhere, and that's been very gratifying to see. Now, the next thing, that area of contestation over who can have firearms relates to those who have a prior record. And Rahimi said that if you are a person who a court has found to pose a credible threat to the physical safety of another, then you can have certain of your Second Amendment rights curtailed in certain ways. And so that's at one. And Rahimi, you'll recall, was this guy who went into like a What's a Burger and credit card was denied and he started shooting the place up. You know, he was just out of control with bad behavior, beating up his girlfriend, taking her head and smashed it into a windshield. Terrible conduct. On the other end, you've got a guy like Mr. Brian Range, who we represent in the Third Circuit Court of Appeals. You know, we call him Jean Valjean. I mean, 40 years ago, he stole the equivalent of a loaf of bread, allegedly. He got some food stamps he wasn't entitled to on a one-time basis to feed his family, and has not had any involvement in the criminal justice system since that time. And fortunately, just in the last month, the Third Circuit Court of Appeals, by a 13-2 vote, 13-2, said that he was entitled to have his rights, his firearms rights, restored. So that's significant, and that shows the sea change between pre-Bruen, where people were applying intermediate scrutiny, and now the history test faithfully applied. It should have been 15-0, but 13-2 is quite good, and we were very satisfied by that result.
So, David, I want to get just a little bit geeky about the Range case, which is the Third Circuit Court of Appeals case dealing with so-called felons in possession. And Brian Range is the plaintiff there, I believe, who has no evidence of danger or violence in any respect. And I think that's admitted even by the Department of Justice. And of course, the 18, 19, and 20-year-old cases, which is the Worth case, the Reese case, and some other cases out there. Here's my geeky question for you as a person that's in the U.S. Supreme Court all the time. How is this going to play out? Because up until now, Elizabeth Proligar, the Solicitor General of the United States, Joe Biden's Department of Justice, needless to say, they were on the opposite side of any Second Amendment issue, of any gun issues whatsoever. But thank God they've been replaced by Donald Trump and Pam Bondi and people that presumably are much better on the Second Amendment. I think they're very good on the Second Amendment. But, I used to be a media surrogate and presidential transition team member of Donald Trump. So I'm a little bit biased in favor of President Trump, and everyone knows that. I guess my question, though, is geeky wise, strategically wise, what can the Department of Justice under Donald Trump do in terms of do they take an appeal from Range and Reese and defend the federal law because they technically run the Department of Justice and oversee federal law? Can they not take an appeal? Can they take an appeal and change sides? Kind of what is the sort of thing that we don't know what the Department of Justice is going to do, obviously. But with that said, what are some of the things that could occur, and maybe what are some of the things that we should be cheering for? Like what is your general thought about where the Department of Justice under Donald Trump might go with these cases that have just been decided in favor of the Second Amendment in the U.S. Court of Appeals?
Well, they've got three options, Mark. Option number one, and certainly what a traditional, deep state administration would do, would be to say, this is a federal statute, a lower court invalidated it, the Supreme Court should take the case, and the Supreme Court would take the case. The Supreme Court, if the Solicitor General of the United States, if the Department of Justice comes to them and says, hey, some lower court invalidated a statute, they're going to take the case, even if it's going to be 9-0 against the government, they will take that case. And so that's what would have happened if Joe Biden had won. They would ask the court to take the case, and it would. Now, of course, the second option they have is just to allow these lower court victories to stand and not take an appeal to the United States Supreme Court. But there's a third option. And the third option is they could file a cert petition, tell the court, look, these are really important issues. You should take them. We're going to continue to enforce these laws. So there's still what's called Article 3 jurisdiction. There's still a case or controversy, but we're going to file briefs on behalf of the plaintiffs. And that's what we'd like to see them do. We'd like to see them get these cases to the United States Supreme Court where we're confident the Second Amendment will win. And we'd like them, though, to acknowledge that we're correct. And then what the court would do is probably appoint an amicus, a friend of the court, to actually defend the constitutionality of the law. So I don't know what they'll do, but that's certainly what we're hoping they will do.
Now, is this the sort of thing that other presidents have done in the past? I seem to have some recollection that President Obama had done something like this in some of the so-called gay marriage cases like Windsor and whatnot. Do you have any familiarity with that history?
Yeah, good memory, Mark. You're right about that. So that is what Obama did. He said Windsor was a case dealing with whether gay couples who were married could take tax deductions. And so they wanted to get this case to the Supreme Court, but the Obama people were siding with the gay rights community. So they filed a cert petition. They said, we're still going to deny these deductions. So there's a case or controversy, but we're siding with the gay rights community. And then there was an outside group that was appointed to argue in defense of the federal statute. So there is a model for it. There's precedent for it. And I certainly hope they do that.
Got it. Great. So, David, now let's turn to a very popular topic here at the Four Boxes that I know we've spent a lot of time on, and that is what I call arms ban cases. These are the types of arms you can keep and bear, which includes, among other things, semi-automatic rifles, the AR-15s, magazines that are so-called large capacity magazines that are really standard capacity magazines. Where exactly are, with Second Amendment jurisprudence in the courts, dealing with these kind of arms cases, the types of arms you can keep, the types of arms you can bear?
Yes, well, Heller was crystal clear about this test. It said that if the arms are commonly possessed by law-abiding citizens for lawful purposes, then they cannot be banned, period, full stop. So let's look at the items you've just mentioned. You mentioned AR-15s. There are approximately 44 million AR-15s in the United States. It's the most popular firearm in the United States. If this test means anything, then surely it must cover the most popular firearm. Likewise with these magazines that hold 10 or more bullets, more than 10 bullets. There are over 500 million of them in the United States. Surely that has to satisfy the commonly possessed test. If you say, well, are they really used by lawful purposes? We can see that from the survey data, that the reason people have this is because they want to, protect themselves or their family or their property. And we can see it from the crime statistics, because even if every long gun used in a crime in America were an AR-15, and the data isn't broken out, so you don't know, is it a deer rifle or a shotgun or an AR-15? But even if we, assume counterfactually that every long gun crime was an AR-15, 99.99% of them would never be used in a crime. Criminals prefer handguns. The left admitted that in Heller. And so, it's just crystal clear that faithfully applied, we should win. Of course, we are continuing to see, unfortunately, massive resistance from the lower courts. I have a cert petition in a case called Snope, challenging Maryland's ban on AR-15s. There's a case called Ocean Tactical out of the First Circuit dealing with magazines. That's up in front of the Supreme Court. The Supreme Court has relisted these several times, so we don't know if they're going to grant them at some point in the next couple of weeks, or if we're going to get a dissent from the denial of cert. But those are the two outcomes in the next few weeks, and we're really hoping we get a grant. This is an important issue. It affects tens of millions, if not over 100 million Americans, lives in one of these handful of large anti-gun jurisdictions that have these restrictions. And the lower courts are just thumbing their nose at the United States Supreme Court. And it's very lawless and very pernicious, and these laws should be struck down.
And David, there's one thing that I'd like to see if you agree with me on. When you're dealing with the in common use test, which derived from various history that was already performed by Heller in 2008, it seems to me, because the in common use test is part of the historical part of the text first, burden shifts to the government, and then there's a historical analog analysis done. The in common use test arises from the history, which means, as far as I can tell, the burden of proof to show that a weapon is not in common use is actually on the government. It's not the reverse that the Second Amendment proponents have to show that an arm is in common use. They may be helpful to do it, but the reality is the government bears the burden to show that some arm they're banning is not in common use because it's part of the history portion of the test. And at the history portion of the test, the government bears the burden. Do you agree with that, or what do you think?
Yeah, I do. What I would say is that test of commonly possessed by law-abiding citizens for lawful purposes is the product of looking at the text and all the history, and out comes this test. And that's all you need to do. If these lower courts want to look at the text and the history, they can. Spoiler alert, what's going to pop out is the test the Supreme Court came up with when they already did the work. And you're right 100%, because this isn't a textual analysis. The burden of proof is on the people trying to defend these bans. And they can't do it because the numbers are overwhelming, regardless of who has the burden. They do. They're just, they can't possibly defend these unless the Supreme Court's going to redo its own test.
So, David, now you mentioned magazines as well. Now, we've just talked a little bit about semi-automatic rifles, AR-15s and the like. How should people, or what's going on in the court system involving these magazine issues? I guess the first question is textually, are they arms? How are this, because textually, are they armed? If they're not arms, I guess they don't fall within the Second Amendment. But how do we analyze, or how should people be analyzing and thinking about these quote unquote large capacity magazine bans, which are really just bans on standard capacity magazines that usually hold more than 10 rounds? So how do we analyze that and think about it in the courts today?
Yeah, so Dr. Samuel Johnson, who wrote the first English dictionary in 1775, he defined an arm as any weapon of offense or defense. And when a legislature bans a firearm with a magazine of more than 10 bullets, what it's basically saying is you cannot have a firearm that fires more than 10 bullets without reloading. That's their whole purpose of this. And so it absolutely is an arm. And the lower courts have acknowledged that, pretty overwhelmingly, that yes, it is an arm. They have different intellectually wrong and dishonest ways of trying to maneuver from there. But it's absolutely an arm. And once it's an arm, it's commonly possessed. As I mentioned, there are over 500 million of them in the United States.
Yeah, and I think if you go back and look at the Bruen language, it says that, modern arms are protected arms, and likewise, anything that facilitates, that was the word they used, any instrument that facilitates armed self-defense is protected textually under the Second Amendment. And obviously a magazine is an instrument, and obviously it helps facilitate. Doesn't say necessary or needed, it just says helps. Basically, that's what the word facilitate means. It helps. And there's no doubt that a magazine that holds more than 10 rounds facilitates armed self-defense, which is why every police officer has magazines that hold more than 10 rounds, and why Americans overwhelmingly choose it. Great. So, David, I think that's very good analysis. Now, I would like to ask you a couple additional questions about other types of cases that maybe pop up. What's going on with these tax cases? And, I look out there and, we cover a lot of these where they try to impose taxes on guns and ammunition. They try to impose particular costs like insurance and stuff like that. But how do we analyze a tax case where the government is trying to impose taxes targeted on guns and ammunition because they don't like guns, they don't like ammunition, and they don't like the Second Amendment? How do we analyze that, and what's going on in the courts today?
So we have cases pending in Cook County in Illinois against their illegal gun tax, and also California also has an illegal gun tax. And I'd say they're unconstitutional for two reasons. First, we just take the Bruen-Rahimi test, which the Supreme Court has said applies in all Second Amendment cases. And we can see that this is an infringement. Obviously, a tax can be an infringement. And then we see, is there any historical analog at the time of the founding? And there wasn't. Guns and ammunition were not taxed to any meaningful degree at the time of the founding. So just on the traditional Bruen, Heller, Rahimi test, we win. But second of all, there's an independent freestanding line of Supreme Court cases. The key one is Minneapolis Star from 1984, where the Supreme Court says we're not going to let legislatures target fundamental constitutional rights with taxes. There, Minnesota tried to tax the ink for that newspapers were using. And they said that's inappropriate. It's obviously you're trying to suppress the exercise of this right. And that's all that's happening in the Second Amendment as well. So we're quite optimistic, we'll get those invalidated. It may take us getting to the United States Supreme Court to do that. But those laws, in my opinion, will fall in the fullness of time.
Yeah, and, in addition to everything you just said, which I agree with, is also you just go back to the 1960s, the Harper versus Board of Elections case out of Virginia, right, where you're literally dealing with a $1.50 poll tax, and the Supreme Court says you can't have a targeted poll tax on voting. So it seems to me, how can you have a targeted poll tax on buying guns and ammunition specifically? It seems like none of this can fly. It's just a question of whether or not you never get a case before the Supreme Court, which is up to the Supreme Court, really, doesn't it?
That's right. That's exactly right, Mark.
So, David, now, during the panel discussion, I introduced back in November at the Federalist Society when we spoke alongside an excellent panel, including Judge Thapar of the Sixth Circuit. I introduced a concept, and I think we talked about, I think you even commented on it in the commentary section of the panel discussion, as I recall, the notion of what I call third rails of Second Amendment jurisprudence. And as you know this better than anyone, you have to derive principles from these historical analog laws, which we talked about a little bit earlier today. And there is an attempt, as I see it, if you look at how a lot of the judges that don't like guns, in my opinion, you don't have to comment on that. I can, because I'm an academic and you're a practicing lawyer. You have to talk to these judges directly. So you may not want to say anything specifically about them. But the reality is it seems like they try to extract such a high level principle, a general principle that is so high that it would literally justify any and all kinds of gun control laws. And it seems to me there needs to be some check. And even Justice Barrett has indicated in the past, there has to be some check on deriving a principle, extracting a principle so high in the name of public safety, if you will, that any conceivable attempt to regulate guns would be constitutional under the Second Amendment. How does these notion of, from your perspective, the notion of deriving principles, extracting principles, applying sort of third rail concepts, how does all this, work generally speaking, if you could explain that to our audience?
Well, the first thing I'd say, Mark, is that this is not unique to the Second Amendment. In every area of constitutional adjudication and litigation, one of the things the courts have to do is come up with a set of analogs and then extract a principle. And you're right. If you do it at too high a level of generality, then just anything goes. Let me give you the First Amendment example. At the time of the founding, you couldn't defame someone. If you said the principle is any harmful speech, is going to be illegal, well, then that would just sweep in all sorts of things. It wasn't that. It was a very, precise understanding of what was defamatory. So too here, for a principle has to be grounded in the how and the why of the analogs. As you said earlier in this discussion, you pointed out the first step after you get over the textual barrier is then for the government to come forward with a large corpus, a consensus of regulations relating to firearms from the right period of time that match the law under scrutiny. It's how and it's why. And by the way, if they don't do that, we're not talking about principles. They lose right there. But if they do that, then yes, principles have to be extracted. And I would really commend to everyone to look at your Harvard Journal of Law and Public Policy argument, because I think it's very good of pointing out if something is inconsistent with Supreme Court precedent, if it violates the text of the Second Amendment, if it violates the purpose of the Second Amendment, if it would have rendered all of the founders felons or mean that, a majority of Americans today can't exercise the Second Amendment right, any of those things, then they need to go back and redo their work because they have not fit within the range of acceptable principles.
Yeah, I thank you, David. I appreciate that. And I think that's absolutely correct because, as the justices have done in other contexts, too high of a principle that you generalize or extrapolate from laws or examples eviscerates the right or just sends you down a wrong path. And, I write about in that article in the Harvard Journal of Law and Public Policy, the discussion of the Glucksberg case, which is a case involving so-called the right to die. And the plaintiffs in that case, as I recall, was trying to argue that there is a 14th Amendment fundamental right under the Constitution to choose when you died and how you died. You have a right to die. And the Supreme Court rejected that concept and said, look, The only thing we can conceivably grant to you is the right to deny. You have the right to refuse to take water. You have the right to refuse food. You have the right to refuse that and refuse medical care, but you don't have a generalized high-end right to die. And that's another example where the Supreme Court really tries to get the extracted principle very narrowly confined and very sort of, I call the Goldilocks principle, and not at too high of a level, at which point, it becomes anything is analogous to anything, right? Everything is related to something at some grand level. And the courts are very careful not to allow that to, in this context of the Second Amendment, eviscerate the textual right to keep and bear arms. Now, with that said, David, I appreciate you taking time today. I just want to ask you, generally speaking, that a lot of lawyers, I believe, watch this channel. A lot of people involved in Second Amendment litigations across America watch the Four Boxes Diner. A lot of people that write on the topic, very interested in the topic. And if you were in a room full of practicing lawyers who fight for constitutional rights, generally in the Second Amendment specifically, are there any sort of practical practice tips that you might want to convey to an audience of lawyers if you were talking to them in a CLE, let's say? What would some of those practice tips be if you had the chance to articulate them?
I guess I would say a few things. Number one, I would stop trying to get preliminary injunctions. That is something that my firm and other firms did after Bruen, and I think it was perfectly sensible to do at that time. But what we're seeing is a lot of the anti-gun jurisdictions in which we have to litigate, you don't win many times in the district court or in the Court of Appeals. And then, the Supreme Court has shown it's just not interested in taking cases that are not so-called final. The technical term is interlocutory, but the basic idea is the United States Supreme Court, and this isn't unique to the Second Amendment, it's their general practices. They like to take cases where there's a complete record and complete findings, and it's at that time and only that time they're going to take the case. And so what we're seeing is it actually sometimes delays the ultimate resolution of the case, because you start with a preliminary injunction in the trial court, then you go to the Court of Appeals, then you go to the Supreme Court. It doesn't work getting it to the Supreme Court, and then you're sent back to the trial court. And, if you had just plugged along, saying, please move on, summary judgment or with expedition, I think you'd get a faster result. So that would be one thing. I think we've learned from trial and error. They're just not particularly interested in interlocutory cases. The second thing that we've seen is that some people want to use expert witnesses on things like history. And we know from Heller and Bruen and Rahimi, you don't need to have historians to win these cases. Judges and lawyers are perfectly capable of gathering the relevant evidence and showing it to the other side. And these are so-called legislative facts. So the judges are permitted to look at any historical source they want. It doesn't have to come from an expert report. The record isn't closed. On appeal, it's de novo review. And so I would just urge people not to try to get into a game of, who can find more academics, to say something. And then the final thing is, this is a fairly new trend again, but we're seeing a lot of conservative judges, both at the Supreme Court, but around the country over the last 5 years or so, they are confining their injunctive relief to the plaintiffs before them. What I mean by that is, let's say, there's a case on behalf of 18, 19, and 20-year-olds saying, like this Reese case, saying, I want to be able to buy a handgun from a federally licensed dealer. The reality is that the ruling from the court is that the actual plaintiff is the only person or persons, if there's more than one, who now have a right to do that. And many of these cases are brought on behalf of membership organizations. And so if you want to take advantage of these wins that we are enjoying in many places around the country, it's really imperative to join one of these Second Amendment groups, because once you're a member, then you're a plaintiff, you're deemed to benefit. You will get the full benefit of that injunction, of that victory. And so it's more important than ever. It's always been important to support the Second Amendment and the groups. But now with this new trend of limiting the wins to the actual entities and their members who are plaintiffs, if you want to enjoy the fruits of victory, you have to join one of these groups.
That's extremely helpful, David. So just to talk about a couple of these things, just do a little bit deeper dive on a couple of these points. Dealing with interlocutory appeals, which, again, for the audience, an interlocutory appeal is an appeal that occurs in the middle of a case as opposed to after the case is over and there's a final judgment entered and then you take an appeal from a final judgment. Interlocutory is before that. And it seems to me, David, one of the reasons why I think the justices on the Supreme Court don't like interlocutory appeals as a general matter is because they don't feel like they have a complete factual record, a complete legal record, a complete historical record. And the reason why that's particularly important for the Supreme Court justices is, when they issue a ruling, as I like to tell my audience here at the Four Boxes Diner, there's two things you want to always look to on a Supreme Court decision. One is who wins the case, very, very important, especially to the parties themselves. But from our point of view, it's equally important, if not even more important, is how they win and lose the case. It's the rationale, the arguments. And it seems to me that justices really want to make sure that before they issue these rulings that are going to last for decades potentially and bind hundreds of millions of Americans in courts, they want to get it right. And they really want to maximize the possibility of them having all the information they need to make a good, well-reasoned opinion and not miss something that might happen on a rushed interlocutory appeal. Do you have any thoughts on how the justices might view this notion of when they hear a case?
I think you've nailed it, Mark. They realize, they're acutely aware, far more so than any other court, that they're not going to see every case. They see a very small sliver. Look at the time that elapsed between Bruen and Heller, and yes, there was Caetano in the middle. But basically, it was 14 years before they came back for a merits ruling on the Second Amendment. So they're acutely aware we have to get this right. We are announcing a rule not just for the case in front of us, but for hundreds or thousands or even tens of thousands of cases that will take place before we turn to this issue again. So we better get it right. Of course, every federal judge is trying to get it right, but the Supreme Court has a huge premium because they have just a limited capacity to take cases. And so that is one of the reasons why they don't want to take a case that has a half-baked record or where the lower courts had to rush because it was, an expedited briefing. And so, yes, they want to take cases that are final. And as I said earlier, this is not unique to the Second Amendment. This is the way constitutional adjudication works across constitutional issues.
Well, speaking of interlocutory appeals, there's a case right now before the U.S. Supreme Court dealing with the PILCA or PLACA immunity statute dealing with protecting arms dealers, protecting gun companies and the like. Now, this is technically an interlocutory appeal because the case is not on a final judgment out of the U.S. Court of Appeals for the First Circuit in Boston. So the question is, David, when you're dealing with an immunity context, what's the story? Is that an exception to the general rule that they don't like, they don't like interlocutory appeals? How do we think about immunity cases versus other cases? Is there a distinction that our audience ought to know about?
There is a distinction, Mark, because the immunity that you are supposed to enjoy is not just from having to pay money or be enjoined. It's immunity from being even subjected to the litigation process, which is extremely expensive and burdensome in modern day America. And so if you as a defendant believe you have a meritorious immunity claim, they're not going to make you wait till the end of the trial or whatever before you can go up. So yes, when there's an immunity claim, whether it's qualified immunity for a police officer or whether it's this immunity under PLACA, then yes, you ought to be. And in fact, the courts generally have recognized that you can go up immediately to the Court of Appeals or the United States Supreme Court and say, time out. I have immunity not just from losing, but from even being subjected to these types of proceedings.
And actually, President Trump took advantage of that in the Jack Smith indictment, where he sought the immunity ruling by the U.S. Supreme Court. And he was successful in that ruling, but he was able to take an immediate appeal to say, I should not be indicted and harassed by Jack Smith, the special counsel, because I have immunity as the president. And obviously, that's another example of that everyone out there is probably familiar with. Now, talking about historical experts, you make an excellent point that whether you look at Heller, McDonald, Caetano, Bruen, Rahimi, there was no testifying historical experts. And it seems to me, again, if you just think about it from a common sense point of view, what lawyers do. So if I have a case today on behalf of a client that did or did not do something 5 years ago involving a contract written 5 years ago, and then there's precedent involving the law of contract, if you think about it, everything I'm about to do as a lawyer is going to be in the past. I'm going to be looking at the contract signed 5 years ago. I'm going to be looking at what happened in the last 5 years. I mean, I'm looking back in time, and then I'm going to look for historical precedents. I'm going to look at case law from 5 years ago, 10 years ago, 20 years ago, maybe even the Constitution 250 years ago. And I'm going to be always looking backwards. So it seems to me that the entire job of lawyers, well, not entirely all lawyers at all times, but generally speaking, when you're in court at least, you spend most of your time looking backwards at the facts as well as backwards in terms of finding legal precedents. So it seems like that's what lawyers do, is to look back and do legal history and not airy-fairy history. Maybe they don't look at the history of period undergarments in the Elizabethan era or something, as I like to say. But in terms of legal history, it's what we do as lawyers. Is that fair to say?
100%. I've got a breach of contract claim right now where it's a 1944 contract relating to World War II, the production of jet fuel for the government. I mean, it's an 80-year-old contract, but nobody's saying, oh my gosh, we need to have experts in to interpret what this 80-year-old contract means. People are very capable of reading those, and they're capable of reading old Supreme Court decisions that are hundreds of years old. They're capable of reading Blackstone or the Federalist Papers, and they're equally capable of reading these statutes, which is what they're supposed to be focused on. It said, tradition of firearms regulation, which means statutes in common law, and that's in the sweet spot of what judges and lawyers do.
Well, David, it's been fantastic to have you on here today. And I just want to say, though, I only have one comment. There's one thing I think you missed on the practice tips, which is the most important practice tip for American lawyers in total. And that is they must absolutely be watching every single episode of the Four Boxes Diner YouTube and Rumble channel to learn about the Second Amendment. I think that's the other practice tip that I'm sure you really wanted to talk about 100% as part of your practice tips.
Yes, I always learn something from your videos. So thank you, Mark, for doing this. It's really great for the whole community. So thank you.
Great. David Thompson of the law firm Cooper and Kirk, handling dozens and dozens Second Amendment cases in America today. So when you all light a candle, when you all say your prayers and you cheer for the Second Amendment, you're cheering in many instances for David Thompson and his merry band of lawyers over there at the law firm of Cooper and Kirk. David, thank you for joining us today. Godspeed. And I hope you prevail in all your Second Amendment cases and then some. And we'll talk to you again soon.
Thank you, Mark.
Orders up. Table 2A.